Hey everyone, sorry for the technical issues we were facing, and thank you for your patience. We had a technical glitch, but we are good now. So let's start. I am going to bring up my PowerPoint um, and start our EB-1A Visa Masterclass. Okay, thank you again for joining. This masterclass, I've been holding these. I used to hold these quite a bit a few years ago. And now I realize that so much has changed in the last year with the new government. I think it's so useful now to start doing these. So what are you going to learn in this master class? So I'm going to cover each of the criteria. There are 10, as you may know. I'm going to go through them fairly quickly, give you an overview, but I'm going to give you insight into each one and what has changed over the last year. And then hopefully you will have a very good idea if you qualify for the EB-1A. And then after I go through the criteria, I'm going to open it up for live Q&A. Okay, so before we begin, I do have to put out the disclaimer that nothing in this presentation constitutes legal advice or creates an attorney-client relationship. And of course, we cannot guarantee outcomes. Okay, done with the legal stuff. My name is Priya Alagiri. I am the CEO and founder of the Alagiri Immigration Law Firm. We are a highly niche, highly boutique immigration law firm. And that means that we only focus on one area of immigration law. And that area is the EB-1A visa. It's like a sub niche. And we only handle EB-1A visa applications for engineers. So I have been practicing immigration law for over 15 years now, representing engineers that entire time. And here are a few of the testimonials. And we're so happy to have helped so many clients, engineering clients, for their EB-1A. Okay, so let's get started from like with describing what is the EB-1A and who it applies to. Many people don't know this because people don't talk about it that much. But the EB-1A is not available to everyone. It's only available to 5 occupations, let's say. So the 5 are, and they're listed here: sciences, the arts, athletics, education, and business. So that's it, those 5. So if you fall into another category, like you're a lawyer like myself, you cannot apply for the EB-1A. So the first thing you have to do if you're considering the EB-1A is make sure you fall into one of these 5 buckets. Okay, so once you determine you fall into one of those 5 buckets, the first thing you should check is if you have received a one-time major international well-recognized award, like the Olympic gold medal, a Nobel Prize, or an Oscar. There's more, obviously. So that is the first thing you have to do. And obviously, if you've won one of those, you probably know, you're extraordinary and you should apply, and you don't need to do anything else. But like most of us, we don't have that one-time major award. So if you don't, this next part of the presentation is for you. You would have to meet 3 of the 10 criteria that I am going to go through right now. So first criteria is awards, receipt of lesser national or international awards for excellence. Um, so these are lesser awards, right? Doesn't need to be an Oscar, doesn't need to be, an Olympic medal. So it's a lesser award, but still needs to be fairly high level. It should be open to the public. School awards do not count, and it should be competitive. So should be a competitive, open to the public process. For it to count. Second criteria, publish material about you. So much confusion around this criteria. But two things to keep in mind about this criteria. So if you look at the name, it's published material about you, right? So it's something in the media written about you, not your accomplishments. It could be about you and your accomplishments, but it should be about you primarily. And, it should be fairly, detailed. And basically, it just shows that you're doing amazing things in your domain or your industry. So someone's writing about you. So that's what this criterion means. And the second part of this criteria is that it should be published in a well-known platform. Okay, membership. This is the one that I have seen change drastically in the last year. Membership in association. So the current immigration climate is to not, in my opinion, not really approve membership anymore. In the last year, I have not seen many, if any, memberships approving this criterion. If you are going to go for this criterion, make sure you're able to document make sure you're able to document the selection criteria. It should be official. And make sure you can also document who are the experts, like who's evaluating the membership. So that's what I've seen. Very difficult to meet these days. 4, judging the work of others. So this is probably the most flexible criterion for engineers. Anytime you're being asked to review high-level work, either papers, if you serve on an editorial board, if you're on a board of directors, even internally, if you're reviewing, technical reports, things like that. So it is flexible. So most of the time, my guess is if you're applying for the EB-1A visa, you very likely could meet this criterion. Okay, original contributions of major significance. So this is probably the criterion that the USCIS questions the most. But then again, I think it's the most important criterion for engineers. A lot of confusion, there's 2 parts to this criteria. So what first is like, you have to have an original contribution. And that's when I have my consultations and meet, with potential clients, oftentimes, there's a misunderstanding of what is considered a contribution. So if you're in the engineering field, a contribution, and this is directly from the Immigration Service, they have explicitly said, in such cases, a contribution constitutes some type of technical innovation. So it's not writing a book or a paper. A contribution for engineers is some type of, you've developed a technical methodology, standard, product, something like that. So it has to be first of its kind. And then the second part of this criterion is your novel solution has to have had major significance in the field. And the Immigration Service lately has really been questioning the major significance part. So they will accept that your contribution is first of its kind or original, but then have a bunch of questions regarding the major significance part of this criterion. Because remember, there's two parts to it. You have to show both. And what they're really asking is what has been the impact of your innovation? How has it moved the needle forward in some way? And you can show that your innovation has had influence in the field. You can by patents if you have them. You don't need them. You can show commercialization, metrics, things like that. Sixth criterion, scholarly articles. Okay, authorship of scholarly articles in professional or major trade publications or other media. So scholarly articles means what it says. Authorship of scholarly articles. So focus on scholarly. It should be high level, technical, written for other technical people. If you're an engineer, it should be written for other engineers. Someone like me or lay people not in your domain, which shouldn't really be, shouldn't understand it. It's written in a highly technical way, and think about it like a white paper. And the conference presentations do qualify. Okay, 7 criterion, critical and or leading role. So this is another criterion that has 2 parts to it. First, you have to hold a critical and or leading role. Sometimes you can hold both. They are 2 different things. A leading role, and again, this is straight from the Immigration Service. They say this all the time. Leading role means that you manage, you direct people, your title. Like if your title has manager in it, if your title has senior in it, your duties, if they're supervisory in nature, managerial in nature, that's a leading role. So you could have a leading role, but if you're an individual contributor, very likely you have a critical role. You may not have direct reports, but you're working on crucial initiatives for your organization. So that's a critical role. And sometimes people meet both. They can have a leading and critical role. So that's the first part. The second part of this criterion is you have to show that you work in a distinguished organization. So always take the time. It's not a throwaway. Don't assume you work at a really well-known organization and you don't have to show it. That's not true. We've gotten questions about, highly, world-renowned, prestigious organization. So make sure you do show that your organization is distinguished, because sometimes you could just get an RFE just on that one part. Okay, high remuneration. So this is another one that's flexible or enough that you should go for it. I don't think we've ever filed an application without adding this criterion. And that's because you have a lot of room to make your case. They don't tell you what is the wage. They don't tell you what benchmarks you should use. Pretty much if you can show that your wage is high compared to others in your field, and again, it says in relation to others. So, there's room there. So how do you define others? Are others like having the same title as you, or others in the um, same kind of domain as you, same geographic area as you? So, there's room there to be creative as long as you can support what you say. And again, don't look at strict salary. You can include your total comp, but you have to compare apples to apples. Um, okay, so now these last two criteria, I'm just going to quickly cover it, but they don't really apply to engineers. So this criteria number 9 is evidence that your work has been displayed at exhibitions or showcases. So the Immigration Service has been very clear. They mean artwork and artistic exhibitions, artistic showcases. So that's the only way you'd be able to meet this criteria if your artwork has been exhibited somewhere. And as engineers, we don't really see that. The final criteria is commercial success in the arts. Again, this is more for artists, movie stars, designers, and it's more about showing your public success in the performing arts. Okay, so you have to meet at least 3 of these criteria. I would never recommend going with just 3. I mean, you should at least have more than 3. So if the Immigration Service decides, they don't agree with one, you're still in play. And we don't have time to go into the 2-step process for the EB-1A, but there is a 2-step process, right? And many of you may know about it. But first, the U.S. Immigration Service is going to determine if you meet 3 or more of the criteria, and if you do, they'll move on to the second step, which is the final merits, and that itself is a whole. That would be a whole other masterclass to discuss that and explain that. Okay, so we would love to help you evaluate your profile. Please contact us. We'd love to hear from you. And we are now going to open it up for Q&A. Let's see. Okay. Subscribe to our channel if you want to ask a question. And maybe I was clear, but I can answer some questions that were put to me before the Q&A that people sent. First question is, do I need publications to apply for the EB-1A? And that is a myth that's been around since the EB-1A was invented. And the reason there's that kind of myth that you need publications is because the EB-1A used to heavily focus on researchers and scientists. So that's why. But if you're an engineer, you do not need publications, and you don't need citations to qualify. It's not in your job profile to publish, to write, to publish, but like it is for researchers and scientists, right? They have to constantly, put out papers, and that's where citations matter. But if you're an engineer in a in the private sector, you don't need publications, you don't need papers, and you don't need citations. It's just not something that's expected of an engineer working in the private sector. So another question that was sent beforehand is, what is considered a distinguished organization? I mean, obviously they're the obvious ones, right? Like FANG companies. But there are a lot of companies that aren't, you know, known, or the names aren't known among the, public, but they still are distinguished in their domain. So you have to make an argument. I will say that the Immigration Service looks for certain things. That doesn't mean that you have to meet your organization has to meet all of those, but they look for things like types of clients, how long has the organization been, in existence, has it received awards? So things like that, I think, as long as you can show. I've often been asked if, I work at a startup, could I apply? And I think before this government, we used to not do early stage startups, but we would apply for the EB-1A for people working at startups. And it as long as you can make an argument, you always have to make your argument, there's been no problem. But I would say with this new administration, if you're going to do that, then definitely make a really strong argument. Make sure you have documentation. Documentation to prove it. Okay, so then another question that was submitted beforehand is, can if you are working internally and you review work internally at your company, does that count as does that count for judging? And since I've been doing EB-1As, we have always at our firm included internal judging. So if you look at the case law, if you look at what's happened in the EB-1A, and we follow all of that. I'm always reading what comes out, what policies have come out, what decisions have come out on the EB-1A. And there have been many decisions from judges saying that internal work counts as internal reviews of high-level work counts. So you have to make your argument again. Okay, let's see. Let me look at some of these chats. Okay, so this is someone who's received an O1, which is great. So for those of you who are not familiar with the O1 has the same criteria, pretty much the same criteria as the EB-1A, the same 10. Role is a little different, but basically it's the same. The difference is the O is a work visa. So the standard of review is much, much lower. The EB-1A is a green card visa. So the standard of review is much higher, goes to a different department in the Immigration Service. But before, if you had an O1 approval, almost automatically you would be given deference, and your EB-1A would, they'd lean towards granting. But I haven't seen that that's really the case as much. It's not written like it used to be. But if you have an O1A, my guess is you meet the EB-1A, and you should definitely apply. There's not much you can do to make it stronger if you've gotten the O1. But contact us. I'd love to talk to you. Actually, you have 30 citations, so looks like you've done a lot of really remarkable work. Okay, next question. Okay, so this question brings up the sustained acclaim part of the EB-1A. So in the last year, two how do I describe it? Two parts of the EB-1A process has really been emphasized like never before. And that is final merits that I talked about. I mean, final merits has been around since 2010, but we didn't really hear much about it ever until this last year. The other one is sustained acclaim, and that's been around, but we've never heard much about it either until this government. So sustained acclaim means that you're not like a one and done, right? You did something maybe 5 years ago was amazing, or even 10 years ago was amazing, and that's it. Like maybe you had one publication in grad school and that's it. So the Immigration Service wants to see that you accomplish something and you've been continuing to accomplish things, that you're maintaining your acclaim. So that doesn't mean, so this question is, are they looking for more recent evidence, like less than 6 months? No, it's not. No, it's not like that. They definitely do not have a checklist that they're looking at. If this is more like the subjective final merits thing, it's going to be the totality. They will definitely notice if you don't have sustained acclaim, right? If you're talking about what you've done just 6 months ago. And that's all you have, or you did one thing, like I said, 10 years ago, and nothing since. So I think it's more obvious when you don't have it. But otherwise, they're just going to look for continued accomplishments. Another question is, what makes an expert letter independent enough? If your work is implemented, you can get, so what's independent enough? I get this question all the time. So independent, I mean, if you think about it logically, the Immigration Service definitely views it this way, is that third-party recommendations carry more weight. So, I mean, it's like the case with anything in life, right? If you have an unbiased opinion given, like from someone who really doesn't care if you get the EB-1A or not, they're just speaking the truth, what they think, then that's going to carry more weight than if you get letters from your colleague or family member or a professor you used to have. Like, so you have to kind of think about it logically, like which recommender would carry more weight. You don't have to have complete strangers, but they should be others in your field. And the Immigration Service definitely will give more weight to independence. We've had clients sometimes reach out maybe to people in their LinkedIn or things like that, but they should also be experts. So your recommenders don't only need to be independent, they need to be experts because they need to speak about your accomplishments in depth. Okay. I think we're running out of time. We only have like 30 seconds left. And I want to Um, yeah, we would love to talk to you. Please contact us. Very quickly, this last question, because I get this question all the time too, and I want to quickly answer it in the last second, is can EB-1A applications, if they're denied, have a negative impact? No, no negative impact at all. So the biggest, I mean, if you apply for the EB-1A and you have an H-1B, or you're on another dual intent visa, and your EB-1A is denied, it has no impact on your work visa, has no impact on your previous perm I-140 or any other I-140. It doesn't impact at all. And also, you can reapply for the EB-1A. So keep that in mind. So, I mean, the two things you're out if you apply for the EB-1A tonight is the money, if you're hiring, if you're working with a lawyer, and time. Other than that, you know, it won't impact your status or your previous green card processes. Okay, thank you everyone. We went a little bit over. It was a pleasure. I'm very, very sorry about the technical glitch. But thank you for joining. Thank you for your patience, and I will see you next time.